Okay, now just a second. Thank you so much, Paul. And thank you everyone who has joined us today. You all know me because we've been in contact, but if we have not met in person, I am Gary Meyer, and I'm with DHH Insurance. I'm sure you know that I work with interpreters and translators and LSCs, and I have been doing so for the last 20 years. And of course, I'm always looking for new information that I can share and bring to my clients. I think it's very important to share as much as possible. Today, we're going to be talking about the new federal law with regards to independent contractors. And I thought this is a perfect topic for this group. So, the plan is we're going to be using a PowerPoint that we're going to share with the interpreters. But before that, before Paul puts that on, I would really like to ask everyone to make sure that they are muted during the presentation. If you have any questions that you'd like to ask, please, we ask you to put them in the chat. And then at the end, we're going to open it up for questions. So if you prefer and would feel more comfortable asking during the presentation, then or at the end of the presentation, please raise your hand, let me know, and I'll spotlight you. But now I'm going to turn it over to Paul. And Paul, if you would like to take over, and you can remove my spotlight as well. Thank you.
Well, good afternoon, everybody. I'm so glad that you were able to join us today. My name is Paul Banuski, and I am a human resource consultant with a company called HR1, and we are a strategic partner of DHH Insurance, where Gary works. And I've had the privilege of knowing Gary for a couple of years now, and we've done some of these presentations on human resource issues, particularly when they overlap with Gary's area of expertise, insurance and risk management. And so we put together an agenda for today that I'd like to share with you. Basically, what we want to do is an overview for you of the change in the federal rule, what that looks like, because we know many of you work with independent contractors, have relationships with independent contractors, and some of you may even be independent contractors. What does this mean for you as agency owners, managers of agencies who deal with the independent contractor relationship? What are the highlights? What do you need to be looking for? And as we put this presentation together, I do want to note that Gary was kind enough to share with me several examples of contractor agreements. So as I put this presentation together, I was comparing what's actually in existing agreements that are out there that I think are pretty typical of the industry, and seeing how they line up with the new rule. So it's been very helpful, and I think you're going to find the information is helpful. The good news that I'll share with you right off the top at the beginning is, based on the contracts and the agreements I've seen, if yours are anything like the ones I've been reviewing, I think overall you're going to be feeling pretty good and in good shape about what these new rules, what impact may be. But it's still important for you to understand what the rules are. It's important that you look at your own contracts and agreements to make sure that basically the way they're worded, the way they're written, line up with what the new rules are, and put your agency in a position where you can confidently say, yes, we are in compliance with these rules. And again, anything that you may need to update or look at, we'll have some specific ideas of things to review, but that's the agenda for today. So thank you so much for joining us. I always like to start with a history of independent contractors, because I sometimes think that there's a lot of confusion about where we get these terms, how these things develop. And essentially, if we go back to really the 1700s, pre-industrial revolution, the people that you might think of as contractors were artisans, craftspeople, right? And then what happened with the Industrial Revolution, we shifted a huge portion of the population into consolidated industries, into factories, into manufacturing towns, all of this consolidation. And as a result of that, employers were exerting a lot more control over their employees. Throughout the 19th century and into the 20th century, we have reform movements that are pushing for workers' rights and protections. These include things like looking for a minimum wage, hour limitations, right? So you're not working 16-hour days unnecessarily. And some of these reform movements got involved in trying to say, well, who is and who is not truly an employee? All of this culminates in the 1930s with the Fair Labor Standards Act. And this is the big piece of legislation that still governs most of what we're talking about today, the Fair Labor Standards Act. And it's been amended. There have been regulatory rules that come into play, but the FLSA is the big piece of legislation that governs pretty much everything we're going to be talking about today. And what the Fair Labor Standards Act did was create this distinction between an employee and an independent contractor. And the way that they do that is by providing wage protections for things like overtime in the law. And if you are an employee, you are entitled to overtime if you work over a certain number of hours in a week. And basically, they recognize that the economic reality is there are some people who just don't fit neatly into that category. And so that's where we get this idea of an independent contractor. It's somebody who is working for themselves, working towards their own profit. They retain control of their actions, but they work in conjunction and at the request on certain projects for these other employers. So that's really where we get this idea of an independent contractor. And hopefully that's very familiar to everybody, because working with interpreters, they are by and large independent contractors, and they fulfill that sort of niche in the economy where they don't quite fit into the category of an employee. They're out working for themselves, but they work with and through agencies. And so that's why obviously there's so much concern about any change in the federal rules and regulations, because this is a big part of how your businesses operate. This is a big part of how your businesses are set up. So that's what we're going to be looking at and reviewing today. So with Independent Contractors 101, if we just think to ourselves, what is a typical independent contractor and what is a typical employee? So employers have responsibilities to their workers. They don't have the same responsibilities to an independent contractor. An independent contractor provides goods or services based on a contract on an as-needed basis. So I made that bold font because it's important to understand it's an as-needed basis when we're talking about an independent contractor versus an employee. With an employee, it's an ongoing relationship. When it's an independent contractor, it is for a certain set period of time. It is for a certain set project or goal. It is not supposed to be an ongoing relationship. So a great example of who's an independent contractor, a graphic artist who does design work for companies. They work with a variety of different companies. They create the graphic, they sell it to those companies. They do their own work on site. That's a classic example of an independent contractor. So we talk about the protections that and the obligations that employers have towards their employees that they don't have towards independent contractors. Some of it is things like withholding taxes, right? We're all familiar with 1099 versus a W-2, right? From the tax perspective when we're working with folks. So employees have to have that tax withheld. Independent contractors do not. Employers are required to offer or provide certain benefits to eligible employees. The big example recently, in the last, say, 10 years or so, was the Affordable Care Act, right? The Affordable Care Act put some requirements on certain employers to provide insurance benefits to employees. That does not apply to independent contractors. Independent contractors are responsible for their own taxes and providing their own insurance coverage. So if you're thinking, what is the difference between an employee and an independent contractor? Benefits is a good way to think about it. If you are providing somebody benefits, they are an employee, not an independent contractor. Now, because taxes are involved with this, we're dealing with, obviously, the Federal Department of Labor with the Fair Labor Standards Act, but we're also dealing with the Internal Revenue Service. So when it comes to an independent contractor, we have to look not only to whatever state rules happen to be in place, and I should say today we're going to focus on the federal rules and the federal rule change. There are some states, like New York State is a great example. I'm in New York, Gary's in New York. New York has some of its own requirements for independent contractors, but today we're going to focus on the federal requirements. So both of these entities, the Department of Labor and the IRS, have come up with tests that employers can use and organizations can use to see whether a particular worker should be classified as an independent contractor or an employee. I'm going to cover the IRS balancing test first. This is a 3-point test. It really is, we're not going to spend too much time focusing on it because this is the test. This has been the test for quite some time. There have not been any recent changes to it. Number one, they're looking at the behavior. Does the company control or have the right to control what the worker does and how the worker does their job? So is the more control you exert over the worker, the more likely they are an employee. The more independence they have, the more they are in charge of setting their own agenda, their own schedule, working at their own pace, the more likely it is they'll be an independent contractor. Financial. So are the business aspects of the worker's job controlled by the person paying, the employer? So, right, if you have an expense reimbursement policy, if you say, okay, well, we're providing your tools, your supplies, right, as an organization, well, you are exercising some control over those financial aspects of the worker. And so that would tend to point in the direction of an employee. And then finally, they're looking, really for written contracts and employee benefits, like I mentioned, right? If you've got a pension plan, if you've got retirement plans that these folks are participating in, then they're probably employees. If you pay vacation, if you pay for their sick leave or any insurance benefits, they are probably going to be classified as employees and not as an independent contractor. So I mentioned the Department of Labor revised their test, and this is what we're going to be spending most of our time talking about today. Basically, what they did was they rescinded some rules that went into place only a few years ago. They returned to something that is closer to what the previous standard was. So when I'm talking today about what the different requirements are, you may very well say, this sounds very familiar, because in some sense, what we're really doing is going back 4 or 5 years to what the old standards were. So you may be very familiar with that. But also what the courts have been saying. So the courts interpret the Fair Labor Standards Act, and they say this is how we interpret it. Well, if the regulatory agency starts to go too far afield, then at some point they need to bring the two back in line. And so this is also trying to bring the federal contractor test back in line with some of the court decisions that have been coming out. It restores the economic reality test. And I'm going to spend some more time talking about the economic reality test. But again, really what we're talking about is, what is the economic reality of the worker? Are they dependent on one employer, on one organization, or are they truly independent? And they are not dependent. Is their economic reality that they are on their own? They are out working for themselves. They have control over profit, loss. They have control over strategic business decisions for themselves. They have control over the types of jobs they will and will not do, and what types of equipment and supplies and training they'll have. And it outlines some core factors to consider. And we're going to be running through what these factors are and how they may manifest themselves within your agency. No single factor is determinative. So this is, when we talk about what the change is, this is something that I think is very important. Under the rules from 2021, there was very much a heavy focus on some of the economics of the position. It didn't necessarily take into account some of the other factors that we're going to be talking about, like employee skill or worker skills, workers' independence. It was really kind of focused on the economic factors. So in a way, this is good. It means there's a more holistic approach to how we determine whether or not a contractor relationship exists or an employment relationship. And it weighs practices more heavily than contract agreement or language. So one of the things that I'm going to be emphasizing throughout today's presentation, we'll talk about policies, we'll talk about agreements, but all of that is only as good as what you actually put into practice. So if you say, yes, this is all in our agreements, that's a great first step, but it's so important to make sure that that's actually what you're doing day to day within your agency. So if we've got a twofold mission today, it's to make sure, number one, that our policies are properly written, that they cover the information that needs to be covered, but also that as an agency, we look at our internal operations and we say, yes, they are aligned with these contracts, with the agreements that we have with the interpreters. So let's spend a moment on the economic reality and core factors that the Department of Labor will be looking at. Really, the more economically independent the worker, the less likely they are to be an employee, right? So if you're providing those benefits, if you're taking withholding taxes, right, then they are probably more of an employee than an independent contractor. If they're doing their own taxes, if they go out and get jobs on their own, if they're not necessarily relying on one single agency for all their work, then that is a sign of independence. The opportunity for profit and loss is an important factor, that each individual interpreter who's an independent contractor, they control how much profit and how much loss they make by their own independent decision making. So that can mean anything from which bids do they pursue, which jobs do they pursue and look for, because again, depending on their appetite, it's in their control. If they want to accept every possible bid and work 60 hours a week, that's great. That's their prerogative. And so that's a factor. The investments by workers and the employer is a big factor when we think about the economic reality of it, right? So if they're paying for their own membership in a trade association, if they're purchasing their own supplies, their own computers, their own cameras, their own headsets, then they are more likely to be independent. If that is being provided for them, well, then that is more of a sign that the agency is exercising control. And again, the more control, the more likely it is to be an employee. And it's a trade-off, right? There are certain economic advantages and drawbacks to having employees and having independent contractors. With independent contractors, you don't have necessarily as much responsibility. With an employee, though, you have a lot more control over their actions and how they behave. So it is a trade-off, and I don't want to pretend otherwise, that there isn't some element of benefit and loss with how you treat these folks. One of the other core factors is the degree of permanence of the relationship. Are you working at multiple agencies? Are you setting things up so that people work where they are proactively pursuing opportunities with you Or are you sort of, you have a stable of people, and in some sense, you've created maybe some de facto employees. I'm not saying that alone would be the determining factor, right? It certainly, if there's a relationship that people are happy with, where the contractor likes what the agency does and the opportunities the agency presents, the agency is happy with the work of the contractor, right? That's fine. You can have those relationships, but it's important that it's not necessarily established anywhere as permanent, that it is each individual bid, each individual job is still something that needs to be pursued, is still something that the contractor, the interpreter, has a lot of control over whether or not they'll take that assignment. Nature and degree of control. This is one of the big ones. You're probably already getting bored of hearing me talk about the control over an employee versus an independent contractor. So again, more control, more likely to be an employee. The degree to which the work performed is integral to the employer's business. So this is a test that they're really looking at. Could your organization as a business function without these folks? Right? If you didn't have these workers, could you still function? So again, think back to that graphic designer example. Now, a graphic designer enhances any business that they work for by providing them the logo, but it's not necessarily the core of the business. So as you define yourself as an interpreting agency, it's important to understand, okay, well, what is the role? Could we still function to some extent or in some ways without the interpreters? Again, no single factor is determinative, but I will say, if there is one area that for this audience you want to pay very close attention to, this might be one of the factors to look at and consider. And again, I don't want to make it sound like you should be scared of this, or you should say, well, our whole business model is built this way. If your business model is that you're a conduit for folks who need interpreting services and folks who can provide those, right, then, right, you need to be able to put those people together and connect those people, but you're not necessarily performing the work. So there are different ways to structure agreements, different ways to talk about your business. But again, in practice, are you working with different interpreters? Are you open to working with different interpreters? These are the things that would be looked at if there were ever to be an investigation or a complaint. The skill and initiative test. So this is a really, I think, a strong factor in your favor as interpreting agencies. One of the things that we're looking at are the people performing the work. Are they bringing a unique skill set? Do they have a unique talent? Do they have a unique initiative? Yes, yes, and yes in this case, right? We're talking about people that absolutely have a unique skill set, a valuable skill set that many different organizations and individuals need and want. So you're going to have, that is a positive factor in your favor. The initiative of interpreters, right? They're going out and they're looking at what are the jobs that they want to do, what are the things they want to pursue, right? So they have the initiative. So I think on that count, it's actually very favorable for interpreting agencies and other groups. Again, that no single factor is determinative. So with the change, they're going back to a more holistic look. So if you kind of look at the whole picture of the interpreter relationship with the agency, they're going to recognize, the complexity of those relationships. So the more that you can have, these agreements that show and that demonstrate, and that your practices show and demonstrate that, this is an independent relationship. These folks are independent. They are economically independent. They have decision-making authority. We can't tell them really what to do in a lot of cases, right? Now, again, each individual assignment, you can have different rules and different expectations that you set, and the interpreter can accept or decline the job. So that's an important factor. The priority here, though, is really protecting the workers' rights. So if you think about philosophically, Where is the Department of Labor coming down on this? Why did they make the change? It's all in the pursuit of protecting the worker. And so, again, the more control you exercise over these folks, what they're going to say is, okay, I want to see that if you're exercising that level of control, the worker is getting the benefit of being classified as an employee and all that comes along with that. If you're not necessarily exercising that much control, you just happen to be working with people who are really good at their job, you're working with people who are independently minded, who are entrepreneurial, right? Then there's not necessarily an issue because you're not exercising the control. And it's going to be a review of the totality of the circumstances. So let's say, if it's a checklist and you were to say, I've got 5 of the 6, right? And it doesn't necessarily work this way, but that's what they're, the totality of the circumstance, right? I think there's also some recognition when they take the more holistic approach that what they are looking for is, there's a recognition that not every industry is going to be the same, right? Your industry has independent contractors that operate differently than the graphic designer, that operate differently than a social media consultant, right? And so that recognition allows there to be different types of independent contractor relationships. But again, in the totality, they are looking at control, they're looking at financial independence. So what is the impact on the industry? Again, the challenge is making sure that your practices match your policies. So like I said, I've reviewed some of these agreements, I've reviewed some of these contracts, and I think the policies are all good. I think the policies are generally, overall, from what I've seen, I would say indicate compliance with the law. So the question then is, are we following what we're putting down in writing? But your policies are critical. I don't want to minimize that part either by saying, well, the ones I've read looked pretty good. I've not read everybody's on this call. I really strongly encourage you to, once we've gone through this, once you've asked some questions, take your agreements and read through them carefully and look at them through this lens of, are we meeting these core factors of the independent contractor test? So here are the things that you should be looking for. Where do we exercise control over the workers and where do we give it up, right? Do we exercise control over how they apply for assignments, how they, right? Okay, that's fine. We can exercise control over, this is the method we've used to have people look for an assignment, bid on an assignment. It's still up to them to actually go through and do it. You're not necessarily assigning work to folks. They are coming and looking at what's available, and they are making a proactive decision for themselves to bid on that job. Who is responsible for equipment, tools, and resources? So look through your agreement. What does it say about that? It should say that the interpreter is responsible for providing their own equipment. Now, you can always say this particular job has a specific requirement for equipment, right? That there's some flexibility there. What you want to avoid is saying in a master agreement or saying this applies to all jobs that we do that you have to meet this standard. So standards are fine on a job by job basis. It's when you start to make demands for all jobs where you could potentially start to move into that area where you're exercising too much control. How much do we do for the contractor versus how much are they responsible for, right? What services are you providing to them? What help and support are you providing to them? And again, it's a trade-off. The more you provide, then the more potential there is that you've created an employment relationship. The less you provide and the less control you exercise, you can maintain truthfully and in reality that this is an independent contractor relationship. And overall, that is, I think, as an industry, you understand that's the most efficient way to be set up. How is this all reflected in the agreements? Do you have statements within the agreements that talk about control, that talk about who is responsible for providing equipment, who's responsible for providing resources, who's responsible for transportation? All of that should be in these agreements. So if we look at this idea of the profit and the loss within the agreement, where can we say, oh, this is something that stands out to me as being a supportive factor for an independent contractor? Do you allow the contractor to bid on assignments? That's a good sign. Your agreement should have something about the process and how you allow for the contractors to bid on their own assignments. Contractors setting their own rates, right? That's a huge key for demonstrating this opportunity for profit and loss and the financial and economic independence of the person. Because if they're setting their own rates, they're in charge of their profit and loss. They can make the adjustments. You're not making the adjustments. You're not out there saying, oh, that's way too much. If it's way too much, then the market will decide and they won't get the assignments and they'll need to adjust their rates. So that's something that they should be doing, that they should have control over. Billing and expense reimbursement terms should always be disclosed up front, right? So again, they have control over their profit and loss if you've given them the appropriate information of here's what needs to happen for you to do business with us or for you to get this assignment from us. And if they make that decision and say, yep, I think it's worth my while, I think it's worth my time and effort to do that, and this is when I'm going to get paid, this is how I submit my reimbursement expenses, I understand that, I'm comfortable with it, yes, I want to make an affirmative decision to do that, or no, I don't want to take that particular job, right? You're putting that decision in their hands by disclosing it all up front. If after the fact you start to quibble, if after the fact you start to say, oh, well, we also do this, or we also have this, again, thinking of your policy versus your practice and where you want to make sure that they're in alignment, that's where, again, it could be misinterpreted that you are exercising control over the employee, that you are limiting their opportunity to make a profit or a loss on their own. Nature of control. Does the contractor have the flexibility to manage the assignments, right? Can they pick the assignments that they're interested in pursuing and they're not being assigned anything, they're not being forced to do anything? Contractors are responsible for their own training, their own equipment, and purchasing decisions. That type of language should be somewhere in your agreements, and it should be your practice, right? That if a contractor says, oh, and what equipment will I need for this job? Well, you should ask the person who requested the job, right? The event or the person or party that has requested the services, they can give you some guidance, but it's up to you. It's up to you as the interpreter to determine what is going to be the most appropriate equipment for this job, what is the appropriate level of training that I need to have to be competitive in the marketplace. Do I need certifications? Do I need ongoing continuing education, right? These are all the types of decisions that the contractor should be responsible for. It should be in their court, not in yours. So I pulled these two quotes, one from one contract and one from another that I think are a good example of good language that I found in these contracts. So this one, contractor shall be free to perform services in any manner the contractor deems appropriate in the contractor's best judgment. It's very clear, it's very plain that the ball is in their court. This next one, all persons engaged in the services you are to perform will at all times and in all places be subject to your sole direction, supervision, and control. You're saying, we don't want this responsibility. This is your responsibility to do this. So I thought these were just two really nice examples that were easy to pull out of the agreements to show you this is the type of language that, when I'm looking through these agreements, really kind of stand out. Another big factor when it comes to the permanence of the relationship, right? That it's non-exclusive. You should never have anything in there like a non-compete. You should never have anything in there saying you can only work exclusively for our agency. That should never appear in the agreements if you want to maintain an independent contractor. If you want to have that kind of control, great. Hire the people as an employee, withhold the taxes, provide benefits if necessary. That's the trade-off. No guarantee of hours and assignments, right? You don't want to guarantee that. Everything is on a job-by-job basis, right? There's no minimum, no requirements for participation in your portal, no requirements for a certain number of contracts to be fulfilled per year if you want to continue to work with and through us, right? This is that element that it's not a permanent relationship if these folks are free to walk away and not come back, or to come back in 6 months or 6 years, right? That they have that freedom, that they have that power is a clear indicator that they are not an employee. So how do we want to define the contractor relationship in an agreement? We want to clarify the non-exclusive nature of it. We want to define the scope of the work as project-based, right? That this is not an ongoing guarantee of work. This is not a job that you'll have for the next 6 months. This is a project-by-project, job-by-job basis. Emphasize that they have autonomy when it comes to how they decide to perform the job, right? The more freedom that they have, the more that they're able to make independent decisions and exercise their own judgment is a great sign that they are truly an independent contractor. Detail the contractor's responsibility for tools and supplies, right? Be very clear in your agreement. You are responsible for whatever equipment, whatever supplies you think you'll need. And again, right, maybe a caveat for if a particular job or assignment says, oh, we would like the person to do this or to have this particular piece of equipment, right? That's fine, because again, at that point, the contractor can bid or not bid on it, depending on their preference and their independent judgment. And then limit, right? Limit integration with company operations. So it sometimes seems maybe a little silly, a little funny how these things can be interpreted, but you could potentially be exercising control over people if you require interpreters to come to a meeting on site, right? To get some direction of, hey, here's how we'd like to do things. The more you do that, the more it reflects that relationship. If you say to the interpreter, hey, while you're working in an assignment that you got through us, we'd like you to wear, a polo shirt with our logo on it, right? You don't want that kind of integration, because if I'm a Department of Labor investigator, that just screams to me that you're exercising control over this person and they are probably misclassified. So what happens when a misclassification occurs? I do think it's important that we cover this so that you're aware of the risks and consequences of falling out of compliance. The first thing I will tell everybody, if you suspect a misclassification, contact a labor attorney, because to reclassify somebody from an independent contractor to an employee, you will want an attorney to help you, to walk you through the steps, to talk about what could happen, because you're going to have to implement corrective measures. Now, that could depend on how long the person has been misclassified. It could depend on sort of the nature of the organization, how much they work for you, right? Because if it turns out you've had somebody who is essentially a full-time employee, now all of a sudden you could be subject not only to back wages, potential back overtime, potential cost of any benefits that they've missed out on, right? You could also be subject then, on top of all of that, to fines and penalties from the government. And those fines and penalties can be thousands of dollars on top of the back wages, on top of back taxes, right? Because if you've had somebody misclassified for 2 or 3 years and you have not been withholding taxes, right, then that's a problem. And the government is going to want their piece of the pie when it comes to these misclassifications. So if you suspect you have a misclassification, contact a labor attorney. They can help walk you through the specific steps of what to do. And then again, at that point, you're going to have to revise your agreement anyway, if people have been misclassified. So these are all the things that you'll have to do if you have a misclassification. So I always encourage people to stay on top of this issue, right? Review the agreements. If you need to revisit them, if you need to update them, that's fine. So again, we talked back wages, overtime, benefits, taxes, and then those penalties and fines. Those are all the consequences of a misclassification. Insurance coverage. So I do want to just briefly mention, and I think it's appropriate that we've got Gary here, because sometimes people will say, well, isn't there insurance coverage of this, right? Because you can treat risk a couple different ways, right? You can either take steps to manage it, reduce it, but you can also insure against risk. This is an area where there's not necessarily great options for coverage. There are some options for coverage. And after I run through this, I'll let Gary add anything that he thinks is important. But generally speaking, claims of misclassification are not covered by your commercial general liability insurance. They may potentially be covered by an employment practices liability policy if you get a wage and hour endorsement. And again, I'll leave the details of the insurance coverage and what's available to the expert, but make sure that you're familiar with your policies and you're familiar with what coverage that you have. And even then, if you can get that endorsement to your EPL policy, coverage may be limited. So in some cases, you may have coverage for the costs or expenses of defending a claim, but there wouldn't be coverage for the cost of any fines, penalties, or payouts, right? And so it's very important you understand what coverage is available, what coverage you have, and what it covers and what it doesn't, so that you can take appropriate steps to protect your business and your company. So what are the best practices that you should leave today with thinking, okay, this is what I think we want to do. We want to review our agreements. We want to make updates to them if necessary, right? If we see something where we say, I'm going to change that language, I want to update that language. If your agreements were written with an attorney, right? Contact your attorney, say, hey, I just was on this webinar and they were talking about some of the recent changes with the rule. I'd like you to take another look at our agreement and our contract. I will say this, I am happy to look at anybody's contract, but really what's going to happen is if I find something in that and I say, I think you should have this looked at, you're going to end up with a labor attorney anyway, and they're going to review it anyway. So I'm happy to look at an agreement. If you want to send it to me, I'll have my email. I believe it's at the chat. We'll have it up again in a moment. Happy to do that, but I will probably tell you if it needs to be updated that you're going to have to contact a labor attorney in any event. Your agreements and your practices should emphasize the flexibility and the control the contractor has, right? That they're in charge of the bids they pursue. They're not limited to working only with our agency. They can go out and work with any agency. There's no exclusivity there. They are in charge of buying and supplying their own equipment. They are in charge of their own training, their own professional development. They are in charge of setting their own rates and understanding what they are and are not comfortable accepting when it comes to work and assignments. And then finally, I think this has broad application to any number of issues within an organization or a business, but seek professional guidance from attorneys, from HR professionals, accountants, and your insurance broker, right? Surround yourself with a team of professionals that you can rely on, that you trust to provide you with good information, good input, and lean on those folks, right? We can't all be experts in everything. So one of the things that, as we kind of close and move into the question portion of this, I'll just share with you is, yeah, my role as I see it is to help employers with their HR work so they can focus on their core business. I think Gary sees it in a similar way, right? He provides insurance and risk management solutions so that you can go focus on your core business. And I think it's a great approach to take. And so with that, I do want to make sure we're answering any questions that are in the chat. I am going to exit the PowerPoint now so that we can use the spotlight to highlight anybody else that does have a question.
This is Gary, okay? So first of all, thank you so much, Paul. I really think that this was some very valuable information that was shared with the agency owners and also with this employment group. And I know that this conversation is going to be ongoing. There are a lot of things to talk about. So I'm still here to help with information. And Paul regularly works with our agency very closely. And so you will see him very often. And we are going to be having conversations about what's happening in this area and in the area of interpreting, translating, and the LSC world in general. What's going on over there? And I know you talked a little bit about the insurance with regards to employment training responsibility. And I've had this discussion with some people, and in the fall, I sent out some information. I shared some information about that. And so this summer, we're going to have another webinar. And we're going to do that about wages and the practices regarding that. So before we close, does anybody have a question that they would like to ask?
So I do want to just jump in. I did see a question in the chat. So someone asked the degree to which work is performed if it's integral to the employer's business. And they asked, can that be interpreted by language? So a Russian interpreter is not 100% integral if we offer 40 other languages. So I think that's a good point. Again, because no single factor is going to be determinative about the employment relationship, I think that would be a contributing factor if you can demonstrate it, but it's not going to necessarily make or break. It's going to be, I think, far more important to focus on what is the language in our agreements and what is our actual practice as far as the independence and control. I think those are probably going to be maybe weighted a little bit more heavily if there were to be an investigation on this particular issue, then whether or not one language is offered versus another. Now, again, if that particular person were the one who were the source of the claim, it might play a bigger role. But as far as sort of a general investigation, and that's the other thing to recognize too, that it's not as if when these rules change, the Department of Labor goes out and hires 10,000 investigators to look into this. When you have a claim, it's because you have a disgruntled employee or a disgruntled independent contractor, in this case, who proactively files a complaint with the Department of Labor, or who is at a Thanksgiving dinner and their cousin's boyfriend happens to be a labor attorney and overhears them and says, hey, have you ever thought about filing a claim? That doesn't seem right to me. That's what generates claims. It's not that they're proactively knocking on doors. So where I think maybe that would play a bigger role is if the complaint came from a particular person and that was the nature of their complaint, they may look into that aspect of it. But overall and generally, I think the best way to protect yourself as an agency is to focus on control and economic independence. But again, no single factor is going to be determinative. It's a holistic approach.
Okay, got about 5 minutes left. Does anybody else have any other questions? If you would like to email me or Paul with a specific question, if you need some advice, we would be very happy to talk to you. So again, thank you so much, Paul. And thank you to all of the participants. Really appreciate it. Have a nice day.